The next case to come before the court this morning is State of Ohio versus Ryan Fitzgerald. Each side will have 15 minutes in which to present your arguments. The appellant may reserve up to 5 minutes for rebuttal. If you wish to reserve rebuttal time, let me know before you begin your argument. I don't think we have to worry about any names of victims or children or anything of that nature. I need to caution you about in this case. Please keep your voices up and remain behind the podium because we are being visually and audibly recorded. We have read your briefs. We are ready to begin when you are.
Thanks, please, the court. My name is Joseph Hada. I'm here on behalf of Ryan Fitzgerald. I would like to reserve 5 minutes for rebuttal.
All right.
This case is a marijuana OVI case. The client was pulled over at 4:44 in the afternoon, and it resulted in an expansion of the scope of the traffic stop into an OVI investigation, which later led to an arrest and a charge of OVI. Primarily, we don't believe that there was reasonable articulable suspicion to expand the scope of that investigation. To draw a distinction, I am conceding that he was speeding. We're not contesting the stop. We're also not contesting any search of the vehicle. What we're talking about is the conversion of a traffic stop into an OVI investigation. And that's where there needs to be that reasonable articulable suspicion of impairment in order to get to that level. And in this case, it simply was not there. It was a speeding stop, and speed is not an indicator of OVI. The manual is quite clear about that. Exceeding the speed limit is not. There are some instances where speed can be. If somebody is varying their speed wildly or they're driving more than 10 miles an hour under the speed limit, that might be an indicator of impairment. But in this case, it's kind of your run-of-the-mill speeding ticket. It's a 39 to 25. It's pretty standard, no indicator of impairment. We have essentially an impaired driving case without any impaired driving. In the NHTSA manual, they teach the officers how to investigate an OVI. They break it down into 3 phases of OVI detection. The first phase being vehicle in motion. They list out 31 different clues of what might indicate impaired driving. And in this case, the record shows that there was actually 0 out of 31 clues. So we've got no impaired driving, no indication that the driver is impaired when the officer pulls him over. He comes to the window, he smells the odor of raw marijuana, and does decide that he's going to search the vehicle. Like I said, we're not contesting that search, but he waits for backup to arrive. He has a discussion with my client about where he's driving to. He tells him that he's driving to Steak and Shake, and there's some question about whether he's on the correct path to be getting to Steak and Shake. But he has been living in Florida. He has lived in the area previously, but he's living in Florida with Florida plates, I believe a Florida driver's license, and I think that there's a familiarity with the area, and certainly while he may intend on returning to Ohio, at the time of the stop he was living in Florida. The officer spoke with him. He was calm and polite, the officer, the entire time. Did not show any signs of impairment. He had a clearness of mind, clearness of intellect, was able to converse with the officer, answer his questions, and did not show any additional indicators. Typically what you see in many OVI cases, I'm sure you know, is the red glassy eyes. And especially when there's an allegation of marijuana, you typically see the red eyes indicative of that. But I believe the record states that I believe the term was 100% sober eyes. He didn't have any red glassy eyes, they were very clear. The other indicators you typically see are slurred speech. His speech was fine, and it wasn't disconnected, he wasn't starting and stopping sentences inappropriately, he was conversing just fine with the officer. He wasn't fumbling with his wallet, he wasn't repeating questions or answers, the typical things that you see in an OVI case. None of those things were present.
At some point, there was an an indication in the briefs that he admitted to smoking marijuana.
Yes, and if I remember correctly, that may have been during the field sobriety testing, but there was a discrepancy between him and the passenger. And I think that that is a good mark of comparison between him and this passenger, because the passenger did have all of those indicators. And the passenger did have the red glassy eyes, and I believe his speech was slow. There was no real question about. I believe they said that he was really stoned. Was the description, I believe, of the passenger. Now the passenger said that there was smoked marijuana, I believe, a half an hour before. I know that when
Said he did, or they both did?
I'm not sure on that. So I'd have to check. I do know that when my client was asked about smoking, he did admit to smoking marijuana, but he said it had been much longer before. He said I believe he said 2 or 3 hours beforehand. Yeah, 2 to 3 hours. So I know when somebody is under the influence of marijuana, their concept of time may go out the window, but if he had even smoked more recently than my client, that may be an indicator of why he looked the way he did when the officer approached the vehicle. So, and again, that is going to whether or not there's that reasonable articulable suspicion in order to expand the scope of the investigation to go from a traffic stop to an OVI. I think firmly we're in an area of good traffic stop. They're allowed to search. If they find marijuana, they give them a ticket for possession of marijuana, and they're on their way. It's a minor misdemeanor offense. In this case, the officer noted the odor of raw marijuana. Raw marijuana being of quite large significance because, by definition, raw marijuana is not burnt marijuana. It hasn't been smoked. It has not been ingested. And if it's raw, then it cannot be, if it hasn't been smoked, then it can't be impairing his ability to operate a vehicle. They do eventually expand the scope of this investigation without impaired driving, without any indicia of impairment from the officer at the window. I'm sorry, not just at the window, because they did remove him from the vehicle in order to search it, and I believe put him in the back of the cruiser. So you've got a long interaction at the window and an interaction in the car with no additional indicia of impairment. And then they expanded the scope and started into field sobriety testing. Shedding some light on whether or not my client was impaired under the influence of marijuana, the officer did 2 tests specific to marijuana testing, or drug testing. The officer was trained in ARIDE, and this is an advanced roadside detection for OVI, where they learn the 7 drug categories and they learn how to investigate marijuana OVIs and other drug OVI cases. He administered 2 tests that would be, that do shed light on whether or not somebody's under the influence of marijuana. One is the lack of convergence test, and the officer did not find a lack of convergence. Essentially, my client passed that test. The other test he did was a modified Romberg test. In the modified Romberg test, it is a measure of the internal body clock. They stand there with their feet together, tip their head back, and they estimate the passage of time. The officer tells them to estimate the passage of 30 seconds, and my client passed that test as well. The plus or minus, the grading on a modified Romberg is plus or minus 5 seconds. So if you come within that 5-second window, you've passed that test.
And your client said like 25 seconds, is that right?
I think so.
He was at the 5 second.
Yes, he was at the 5 second, but I mean, as far as the grading rubric goes, he did pass that test. So we've got 2 tests where these things are designed to test for marijuana, and my client passed both of them. I can't say that the passenger would have, but my client passed both of those. So we've got no impaired driving in an impaired driving case, where they come to the window, they move into that second phase of detection called personal contact. They have no further indicia of impairment in order to move into field sobriety testing. And then when he moves into the field sobriety testing, on marijuana OVI, my client passed those tests. So
He also did the one leg and the walk and turn.
he did the HDN one-leg stand walking turn as well, yes. The HDN, I don't believe you found anything, and you wouldn't expect to in this type of a case. But when it comes to the walk and turn and one leg stand, those are tests for alcohol specifically, and even more specific than that, they are only a predictor of BAC. They've been scientifically validated with a very strict instructions and grading protocol, and that scientific validation extends only to a predictor of BAC. In fact, the validation studies in the manual say that this isn't for impairment.
How do you do on those two tests?
I don't believe he passed the walk and turn one leg stand. But
Was there a reason, did he have an injury, or was there any specific reason that you know of that he would not have done well on those, if it's just an indication of BAC and not affected by marijuana use?
I don't have anything with regard to any injury that he had, but my experience, I have seen people, and even the validation studies show that people will exhibit some clues even when they're not impaired. But
Counsel, I'm sorry. You can keep going. I wanted you to know you're about 30 seconds into your rebuttal time.
okay, I'll just wrap up.
I was
that.
engrossed in your argument,
Yeah, that's
so I
right.
apologize.
So just to wrap that one point up, the validation study says quite plainly, many people, including some judges, feel sobriety tests measure impairment, but rather the study shown and the manual states that they do not measure impairment. They're only scientifically validated as a predictor of BAC and not a measurement of impairment. So I'll reserve the rest.
All right, thank you. Okay, whenever you're ready.
Thank you. May it please the board, my name is Brad Proudfoot. I'm the Assistant Law Director for the City of Wadsworth, and I represent the respondent state of Ohio. Your Honors, instead of going through everything at first, what I'd like to do is focus on some of the facts that were earlier discussed as it pertains to the evening in question. First, they acknowledged that the appellant was speeding and had a reason to be pulled over. The appellant also stated that he and his friend were going to Steak and Shake. Now, there's no Steak and Shake in Wadsworth, and the street in which he took was a side street that took you into, I believe it's right off of Westview or Westwood, and there's no way out to any of the main thoroughfares. You don't get to Main Street, you don't get to College, you don't get to any of those. So his story didn't quite make sense, and there was concern, if you reread the testimony, that they were attempting to evade him. Second, once they were pulled over, the officer stated that he smelled marijuana strongly, the odor of raw marijuana. We also have the admission from both individuals. So we have two separate admissions. The passenger himself, who opposing counsel so eloquently stated was highly stoned, he was much worse off. However, that individual had indicated in his test, or when he spoke to the officer, that they had smoked earlier. In fact, they had actually smoked when they were entering the car. Further, you have the appellant himself, who admitted to smoking. Now, he didn't admit to 30 minutes ago. He did state to the officers it was approximately 2 to 3 hours. However, 2 to 3 hours is the time frame for psychoactive drugs, and the officer even testified to that in the you can see it on the transcript on page 89. So even if we take that as true, he could still be under that psychoactive drug. Now, there was also admission of a bag of marijuana from the driver, from the appellant. He admitted that he had approximately 2 grams. They found drugs on the passenger as well. So you have this corroboration, you have the drugs. They actually found alcohol in there as well. And if I'm not mistaken, I believe they were underage. Now, once they were pulled over, everything didn't go quite as smoothly as opposing counsel pointed out. In fact, when the appellant was asked for his address, what his home address was, he misspelled his own street address.
So a Florida address or a?
Correct. Correct. He misspelled it. I think it's Esmeralda Drive. He misspelled it to the officer. So that sort of jumps out first when you're looking at the identification card for Florida and you can't spell your own address. So those facts were all before anybody was actually removed from the car, before Officer Pettit showed up to assist. Then once they were separated, they could independently smell marijuana on the individuals. Further, the divided attention tests were performed first. So there was a request to recite the alphabet, and honestly, I don't quite remember where it started and ended, but appellant passed that fine. The next on the divided attention test was counting backwards. Now, this was slightly different than what was being portrayed. So the officer had asked him to count down from 69 to 54. And the testimony of the officer, and it's in the judgment entry from this motion to suppress, was that the appellant paused on multiple occasions, took pauses to figure out where he was with the numbers. And in fact, at one point asked, what number do I stop at? Is it 54? And I believe that's on page 85 of the transcript itself.
Counsel, I don't recall, was there a body cam here in this case?
Your Honor, I can't answer that. I'm not sure.
I'm thinking maybe not, or we, each in the group of us, we might have recalled it. Okay, thank you.
So you had that prior to conducting any of the field sobriety tests. Now, we'll readily admit that the HGN test, the appellant passed. There was no issue there, and we wouldn't expect there to be an issue either. Now, as to the walk and turn test and the one-leg stand, yes, there is literature out there that they are only indicative for alcohol-related offenses, etc. However, if you take a moment to actually look at his performance on that, and I believe there was video of this that was reviewed at the motion to suppress hearing. So the trier of fact was able to actually see this as it occurred. And in fact, in his judgment entry, the trial court's judgment entry, he stated that the individual did very, very poorly on these. So with the one leg stand, he put his foot down, he raised his arms, he was swaying, and in addition, he never even counted out loud. So that could be indicative of his inability to follow instructions. Further, the walk and turn test, they observed 5 out of the 8 clues. And this is where the trial court said that they did very, very poorly on these parts of the test. He raised his arms for balance, he stepped off the line, he did an improper turn, he did not do heel to toe, and at times he was literally walking on top of his own feet, which in the officer's testimony, the officer stated he'd never seen this in all of his years of conducting field sobriety tests, that someone was stepping on their own feet doing this test. Now, if we assume that these are only indicative of alcohol impairment, and if he's saying he didn't have any alcohol, what's going on that's causing this? It's almost troubling that someone is stepping on their own feet while they're attempting to walk. Now, as to the lack of convergence in the modified rhombus test that were discussed earlier, the lack of convergence, the officer did state that he did well on that. Now, the modified rhombus test, again, as Judge Callahan had asked and brought out, he actually stopped at 25 seconds instead of the 30, which I guess you could say is right on the borderline of what they consider appropriate. However, there's testimony that as he was doing this, he was swaying back and forth, and then subsequent to this test, after it was completed, the officer stated that Officer Pettit came up to him and said, hey, his eyes were not closed all the way while he's doing this. And the purpose of having the eyes closed is I think, twofold, really, to see the eye tremors, and plus, it also requires or forces you to really focus on your balance, whereas if you can look, you shouldn't see as much swaying. Now, opposing counsel did not touch on the urine test, which was in their appellate brief, but I would like to take a second to discuss that, especially in regards to the trier of fact in the journal entry where this motion to suppress was denied. The trial court in their entry stated, upon reviewing the requirements, it does not state that a preservative may not be added. In fact, Mr. Perch testified, the current regulations leave that up to the testing labs, and they have the discretion as to whether or not to add a preservative. In this case, Mr. Perch testified he did add a preservative of sodium fluoride, but that would not have any effect on a marijuana test. So under State v. Plummer, the threshold here is you have to have a showing of prejudice to a defendant, that the results of this urine test administered in substantial compliance with the OAC are admissible in a prosecution under RC 4511.19. So there are arguments, I believe, threefold. One, that they shouldn't have put the sodium fluoride in. Two, it's not in their own laboratory manuals. And three, that as such, it shouldn't be permitted. But the only evidence that was before the court, there was no other expert that was put on. That expert said that substantially complies, that the sodium fluoride that was added would not affect a marijuana test. And as I stated, the preservative had no effect in this particular case, so it's not a violation of the regulations itself. And even if it would still be in substantial compliance, and the appellant had an opportunity to put their own expert on to counteract the direct testimony of the state's expert, and they never did. So this was the only thing before the court. Again, I apologize. I believe I've touched on the key points that I wanted to touch on. I do believe that the trial court did not err in denying the appellant's motion for the motion to suppress, because there was reasonable suspicion to detain for the OBI investigation. There was probable cause to arrest when you look at the totality of the circumstances. And further, on the testing itself, there was substantial compliance with the OAC, and we had uncontroverted testimony from Mr. Perch himself that this preservative had zero effect as to the results of a marijuana test. So in view of all that foregoing, the state respectfully prays that the decision of the lower court was correct and the decision denying the motion to suppress be affirmed. Thank you.
Okay. Mr. Crawford,
Yes.
you want a couple cocktails?
If you don't mind, thank you. I'm trying desperately not to cough it.
Can you reach?
I can.
You have 4 minutes and 16 seconds.
Thank you.
Ready.
Again, this is an impaired driving case without any impaired driving. And quite frankly, it's not illegal to drink and drive. It's only illegal, it's not even illegal to have smoked marijuana at some point in the past and operate a vehicle. It's actually only a crime if they are impaired when they're operating that vehicle. And all of the indicia indicate to the contrary in this case.
Counsel, let me ask you a question, because you really got me thinking about the walk and turn and the one-leg stand and NHTSA's, basically, it's applicable to BAC. But let's say you had a driver who was heavily medicated, Valium, Xanax, Ambien, whatever, and could not perform those tests correctly. Absolutely couldn't balance, couldn't stay on the line, whatever. Would a court or an officer have to discount that because alcohol was not an issue in the case? How does that come into play?
Well, I think there's a distinction here between, because you're bringing up a few different things. These are, there's a distinction between the overall impairment to that person, because you're going to have a lot of other symptoms to show, and not just the walk and turn and one-leg stand. In some of the medications that you indicate, those are things that would show up in an HGN test as well. But those also are things that show up with slurred speech and a disconnect in intellect in the conversation. Not just how they show on a test. Now, there's no indication of that. To my knowledge, there's nothing showing in any test results, nothing in any other indicia of impairment. nothing else here other than the allegation of marijuana, and the 2 tests for marijuana said that he was not under the influence for that. I know we talked about the field sobriety test, but a large part of this, of our case here, is whether or not they even get to conduct those field sobriety tests in the first place. And they need that indicia of impairment. I understand that they did admit to having smoked marijuana in the past, they had marijuana on them, but having marijuana on them, raw marijuana, is not an indicator of impairment by definition. It's similar to having an unopened, like, 6-pack of beer in the car. If it's not opened, it never got into their system in order to be ingested and to impair them. So when it comes to just conducting the field sobriety test in the first place, we don't get there. The officer had him do the alphabet test. He did it correctly. He had him do the counting test. While he may have paused or asked a question, he did it correctly. He started on the right number, stopped on the right number, and when in the NITS manual, they don't give you a lot of grading criteria on these. They're non-standardized tests for a reason, and part of that is they don't have any real grading rubric for how to handle these. So the officer looks, he said, followed the instructions. Did he follow the instructions? Yes, he started on the right letter, stopped on the right letter, and passed that test. Counting test. Started on the right number, stopped on the right number, he passed that test.
Was he instructed not to pause or keep his eyes closed, etc.?
No. And the eyes closed only goes to the modified Romberg test. The counting, I know you count in like Romberg when you estimate time, but I'm talking about the counting test.
No, I understand.
Okay. So in this instance, I mean, we very well may have a situation here where we've got an impaired passenger, and I'm not drawing any conclusions about him. I know he wasn't tested, but by all accounts, we have an impaired passenger and a sober driver. Talk about how we want people to use a designated driver. You want to have somebody sober operating that vehicle. And in this instance, whether or not they have marijuana, whether or not they should have written them a minor misdemeanor ticket for possession, that's one thing, but they're not getting into a point where they have the reasonable articulable suspicion in order to conduct the test in the first place.
Okay, with that, your time is finished. Thank you for both of your arguments. We really appreciate it. They were both very interesting. Take the matter under advisement. We will issue a written decision in due course. It will be mailed to both sides as well as posted on our website and that of the Supreme Court. Have a good day. I hope you feel better.